Alex, it's nice to see you and welcome back to New Mexico in Focus.
Thank you. Anything I can do to support public broadcasting in this moment in history.
Thanks for doing that. We all had the same question, my news team and I, after we saw the letter, the Sam Bregman letter that Nash just mentioned, and the question was basically, can Bregman do this? I'd like to tackle that question in a couple of different ways, and I'd like to start with the law. What do you make of Sam's threat in that letter in terms of the various legal contexts in which it exists?
Yeah. You may remember in my office, I used to have this print I got in a lot of trouble for having behind me at the desk. It said, "Laws aren't real." Right? And I like to ground any conversation about the law in this fact, that laws are words that we have come together and agreed that are the rules by which we should abide, but they only exist so far as we believe in them. Right, and so this is really important when we're thinking about the laws that the district attorney is talking about here. We're looking at false imprisonment, which was the specific one outlined in the letter, and how it would be used against folks who violate the law. In the district attorney's terms, a federal agent who makes an arrest without probable cause, reasonable suspicion, or a warrant might be subject to local state laws. And the broad answer to that is that's true, right? Everybody is subject to the rule of law. Tons of caveats to that, of course. As a lawyer, you know, it depends is our favorite answer, and that's true. So while the laws always apply, how they apply and whether they can be applied are separate questions. And so how they apply in this case, right, you're looking at false imprisonments. False imprisonments requires a knowledge that your imprisonment of a person is not lawful, right? You don't have the lawful authority to do it. Of course, we trust our police and our federal agents by statute, by law and constitution with the ability to imprison people, right? Because it's a component of their job. So this makes it a little difficult to talk about how false imprisonment might apply to a federal agent. There's a couple other components too, of course, right? We're talking about state law, federal law, and we've heard, of course, the terms of federal supremacy, and I think that term doesn't quite carry as much water as many people believe it does.
How not?
So federal supremacy, right, is the idea that if a federal agent is doing their job, basically, right, there's legal words for it, but if they're doing their job, the state shouldn't interfere in that. That means that the actions they're taking are necessary and proper in advancing whatever the federal interest or the federal law that they are pursuing. If they are not doing something that's necessary and proper to advance a federal law, then that supremacy doesn't protect them from state criminal prosecution. The second sort of procedural piece, of course, is when cases are brought against federal agents, they can be then removed to federal court, where federal rules apply, but state law, in terms of the charge, still applies.
I want to go back to those three standards that you just mentioned. Judicial warrant, that's a warrant that Sam would ostensibly come up with himself, a judge would sign it. Next, you've got probable cause, and last, you've got reasonable suspicion. I want to home in on that for just a moment. How do you think about reasonable suspicion in terms of the possibility of charging a federal agent for false imprisonment? What's that standard?
Yeah, and so we're looking at a broad range of activity, if you're looking at, for example, at Minneapolis or in Los Angeles, of things that federal agents are doing that we might consider, or that the district attorney might consider as a component or target of this letter. That is everything from making an arrest of somebody who is committing a crime, making an arrest of somebody who is not legally in this country and subject to removal, or detaining somebody for any less reason. That's usually where reasonable suspicion comes in, right? So that's the Terry stop. It's where an officer has to hold somebody temporarily, seize them, right, in violation of the Fourth Amendment, but with justification, that being the reasonableness, right? The Supreme Court's recently advised us that ICE agents, when you're carrying out immigration enforcement, have quite, and I would say disturbingly, low bar to prove there, right? Such as your skin color, the language you speak, and the job that you have might be enough to establish reasonable suspicion for a stop. And so if we're looking at where, you know, the justification an officer would give for his actions, if charged with false imprisonment, you sort of got to look at the lowest barrier and see what would qualify, what would not. With this ruling from the Supreme Court and with that very low barrier, which includes, right, such things as crowd control, public safety, right, the neighborhood you're in, how you look, the language you speak, and the job you have, it's going to be very difficult to assert that agents didn't have at least that basic reason to go talk to someone and seize them temporarily.
As a separate matter, I think part of what I'm hearing you say is that it would be exceedingly rare to find a fact pattern in a case, a specific instance where none of those thresholds is met with an ICE agent detaining someone. Do I have that right?
It'd be really difficult, not impossible, right? You know, there's a million hypotheticals. And there's a lot of instances that we're looking at in Minneapolis where it doesn't appear that there is any justification at all for some of the seizures that are occurring. Remember, seizures are everything from putting a person in handcuffs to maybe pointing a gun at somebody, right? That person is considered seized.
Or in the back of a squad car, for example.
Or especially if you're in custody in the back of a squad car. And so there are situations that might exist. It's going to be a tough thing to prove it.
Let's spend just a moment on the mechanics of all of this. I want to let you know something. We contacted APD and BCSO to ask, like, what would you guys do if the DA's office asked you to go arrest an ICE agent based on this sort of framework that Sam's come up with? Of course, they both demurred, saying that we're not interested in commenting on the hypothetical. You and I are here to very much talk about that exact hypothetical. What steps would need to be taken, would the DA's office need to take? Just walk me through the process if Sam sees one of these and believes that it fits those criteria.
Yeah, and so, you know, I have some experience in this on the federal side, right? And so when I was United States Attorney, we charged police officers with what we call deprivation of rights, violations of Section 242. That includes local police officers in the Joliet Police Department, includes a Border Patrol officer for deprivation of rights. Often what that meant was that we were able to conduct an investigation. If you look at, you know, the work we did in that Border Patrol officer case, for example, we had the office, you know, OPR, Inspector Generals from inside the federal agencies conducting investigations of evidence that they had in their possession, and then handing it over to the prosecutors to build the case and bring the charges. So at base level, what you need to bring a charge like this is access to the scene or access to the evidence and access to the witnesses to prove the case.
Wouldn't you then next, once you've got all of those things together, you have to have a warrant? So the next step would be the judge, right? Got to get a judge to sign the warrant.
Yeah, I mean, you could, and so there's a couple options there. I mean, you need to take it to grand jury, who would need to issue the indictment, and then you could either issue a summons or a warrant, right? And so that's a choice by your prosecuting agency, is whether they want to go put a person in cuffs, and yes, a judge would say you can go put this person in cuffs, or summons them to the courts to appear for their first appearance.
If you go the warrant route, I think that triggers an arrest, essentially, right? So if APD and BCSO, let's just assume for sake of this conversation that they're not going to go and do that. They're not going to effectuate that arrest. What options does the district attorney have then?
Yeah, so my understanding is the DA has a number of investigators who are sworn personnel who I believe can conduct arrests. There's probably a dozen of them or so. They don't have the street presence that Albuquerque Police or Bernalillo County does. And so I think if Bernalillo County and Albuquerque Police are not going to effectuate that arrest, it would have to be one of the DA's investigators.
Sounds like an awkward moment for one of those investigators were Sam to walk across the office and say, I need you to go put handcuffs on an ICE agent.
Yeah, it definitely would. And that was the unique thing about doing this, the Border Patrol case, right, where we had the cooperation of the agency, right, doing an investigation of the Joliet Police Department, where we had the cooperation of the agency, right? And so when we, this is part of what's different in today, which is if we're looking at Minneapolis, for example, we don't have federal local cooperation in law enforcement. And that does create an additional level of awkwardness, maybe, to executing this.
That is a good segue into us opening the lens a bit for the end of our conversation. I'm going to read a quote from an op-ed written by a former assistant U.S. attorney and ask for your reaction. He writes, Bregman has chosen political theater over public safety. His recent threat to prosecute federal agents for enforcing federal law is legally wrong and reckless. It misleads the public, encourages confrontation with law enforcement, and promotes a false narrative that could get someone seriously injured or killed. What do you make of that framing?
Sure, I mean, I got a lot of feelings about it. The first really circles back to where we began, right, with the trust of the public, right? This republic, this democracy, this country is built on the trust of the people, and that trust has to be earned, right? As a chief federal law enforcement officer for New Mexico, I believed every day my job was to prove to the public, not just keep them safe, not just do the job of investigating crimes and putting cuffs on people, but to prove to the public that they could trust me, right? Trust can't be ordered, it has to be earned. And so when I'm thinking about these words from my former colleague, Reeve Swanson, I'm thinking about a world that may have existed in the past, where there was trust earned by the federal government, by law enforcement, who showed, right, like in Border Patrol's case, that they would conduct an internal investigation and they would turn over the evidence to, federal prosecutors, and that we would then charge this person who rammed the person's head into the wall. This trust has been broken over the past year by this administration, by the actions that we witness every single day in Minneapolis. And so when the trust is broken, it's tough for a government to ask a people to order people to just comply when they have not earned that trust. When we see day to day actions in Minneapolis against people who are not even involved, who are standing on the sidewalks, actions like spraying them with pepper spray or pointing guns at them or slamming them into the ground. Actions that here in New Mexico we have charged federally as deprivation of rights and convicted federal agents for. And so this is a different world, right? Convicting federal agents for depriving people of rights is important to establishing that trust in the system. And when the people don't see that happening, right, it's important for our leaders to stand up and say, no, the law applies to everybody, right? And so we talked a little bit about the troubles, both legally and practically, in executing this letter from the district attorney. Nonetheless, it is important that the people understand that there is a rule of law and that will be enforced, and that they see that their leaders will take that stand and hold that line so that they don't have to on the streets, right? I think this undercuts the argument and the premise of this op-ed, which is people won't feel like they have to take to the streets and obstruct and get in the way if they know that their leaders and their public officials would do that for them.
Alex, thanks so much for coming in to help us understand this a bit better.
Oh, my pleasure. Thanks, Jeff.